So I think that we're going to get started in here, everybody. Hello, hello. My name is Becca Tabasky. I use she, her pronouns. Welcome to the Berkman Klein Center and our lunch. It's election day in the United States. If you can vote, I encourage you to. Big day. So I'm the director of community here at the Berkman Klein Center. We're so grateful that you're here. We want to start by acknowledging that Harvard is located on the traditional and ancestral land of the Massachusetts, the original inhabitants of what is now known as Boston and Cambridge. We pay respect to the people of the Massachusetts tribe, past and present, and honor the land itself, which remains sacred to the Massachusetts people. Our guests today are Kate Bertash, director of the Digital Defense Fund, Cynthia Conti-Cook, tech fellow at the Ford Foundation, and Yveka Pierre, senior litigation counsel for If, When, How, Lawyering for Reproductive Justice. Our moderator today is Alejandra Caraballo, clinical instructor at the law school's Cyberlaw clinic. So today we are exploring the impact of the Dobbs decision on abortion access, especially how technology is being used or will be used by those seeking to criminalize abortion during this era of increased digital surveillance. Both legacy and grassroots organizations in the United States continue to operate daily while having to parse digital vulnerabilities and the shifting legal implications of multi-state bans. We are going to discuss ways that both the legal community and technologists can understand these developments and plug into ongoing efforts. Our guests today represent grassroots groups who are leading the work to limit the harms of technology in ways that ensure that more equitable healthcare access is available. While today it's specifically geared towards understanding the digital privacy and security needs of reproductive health clinic patients, and specifically pregnant people, we acknowledge that this loss of rights to healthcare access occurs during a broader struggle for bodily autonomy for women, people of color, immigrants, LGBTQIA people in this country. We hope that you will all follow up with us to elevate equitable and inclusive care for all. For our virtual audience, thank you for joining us. And if you wish to ask any questions or leave any comments, please use the question and answer function in Zoom. And this is a friendly reminder to ensure that your mics are muted during the event. Thank you so much for that. And we strive to create inclusive and accessible events here at the Berkman Klein Center. For any questions, comments, concerns, or ideas for future gatherings, please contact us at events@cyber.harvard.edu. Your feedback is critical to our success. To stay in the loop about future events, head to cyber.harvard.edu/get-involved. And thank you again for joining us today. Thank you, Alejandra, for leading us off and kicking off and making this happen and for all your work. Thank you so much.
Thank you. So I just wanted to start off a little bit by saying I'm very fortunate to have Yveka and Cynthia in particular, because both of them were co-authors on a wonderful paper dealing with interstate extradition post-Dobbs. And Kate is a very long time friend of the clinic, particularly with Digital Defense Fund. So it's really great. I haven't actually met them in person, so this is really great to have met them in person finally. So this is a really wonderful day on that end. So today's election day, right? So this is the first major election since the Dobbs came out. And what happens today on election day is really going to dictate what's going to happen in terms of abortion access and abortion rights across the country for the next 2 years. We've already seen a national ban introduced in the Senate, and if Congress changes hands, we could see a push for a national ban, as well as several state legislatures enacting newer, stricter bans, or even more direct initiatives being voted on, particularly in Michigan and other states. So just kind of a bit of a recap, as from the Guttmacher Institute as of today, there are 12 states with complete bans, 2 states with restrictive early bans, around usually 6 weeks, 12 states with restrictions around 15 weeks, and 11 states that have protections for abortion, one with the most protection, which is Oregon. We've seen a lot of bills more affirmatively passed in states like California, Connecticut, New York, to try and protect the right to an abortion. And not just for the citizens of their own states, but to make sure that if anyone's coming to seek abortion care in those states, they can't be, their medical records and other things can't be sought by other states. There's some limits to that, and I highly recommend reading our paper when it comes out in the CUNY Law Review next month, dealing with some of the more thornier issues and particulars of interstate issues around abortion access. But we've also seen kind of a lot of proposed bills, and this is where really things are going to start to change next year. Some of the more egregious ones are some ideas around being able to sue out-of-state providers. This is a bill that was introduced or floated in Missouri, where they would introduce a private right of action. And that's what we've really seen is this kind of broader use of private rights of action to basically bypass any constitutional protections. Is we first saw it with SB8, but this is becoming a growing tactic. And the other aspect of it is the companies themselves, big companies themselves that have employees in states with abortion bans in their response. Several companies have responded saying they'll cover travel for abortion to other states. Legislatures have started to respond and trying to limit that. There may be additional issues with ERISA, I guess, in a complicated healthcare law. But a lot of this remains to be seen what will happen. The other aspect of this is how technology plays a role. Before Dobbs, Roe had been the law of the land for nearly 50 years. If you go back to 1973, barely anyone owned a computer. I don't think there was pretty much any home computers. At most, you had a telephone at home, and you were fairly well off if you had a TV as well. And so that's a completely different set where today we have smartphones that track your every movement, apps that track that you can input and your menstruation data and track your menstrual cycle. And all of that is subject to discovery by law enforcement. And so there are many ways that kind of this surveillance state or surveillance capitalism has been turned on its head and can be used in many ways to criminalize what had been a constitutional right up until this past June. So I wanted to start off with Cynthia, particularly because she had written a very excellent paper about this in 2020. I believe it was in the Maryland Law Review, called Surveilling the Digital Abortion Diary. She helped very much with our newer paper, but her background is as a public defender in the Legal Aid Society, but now works at the Ford Foundation. So Cynthia, I wanted to start with you, and I had one particular question to start off. Criminalization of abortion is not new, especially for marginalized people such as Black and Indigenous women. Can you talk about some of the ways abortion criminalization has worked pre-Roe, post-Roe, and now post-Dobbs?
Sure. Thank you. It's nice to virtually be with you all today. I'm sorry that I can't be huddling on stage with you. It would have been really joyful. Joining in my personal capacity today, and happy to answer that question, but also mention that as Yveka and I sort of journeyed through the section of this extradition paper that we wrote together, it was very clear that criminalization from a much longer view was relatively new as a phenomenon in law, at the same time that it does have, and policing of abortion does have history, and history that we can look to in an instructive way to sort of suggest to us how it will likely reinvent itself as we move forward. So that's to say that up until, sort of the late 19th century, there wasn't a whole lot of history of criminalization of abortion to draw from. It was very much something that was that happened in a realm that was outside the purview of state eyes and surveillance, with the exception, of course, of the huge amount of surveillance and control that happened over the reproductive lives of women that were subjected into slavery. the criminalization by the state started to occur in the way that sort of we're talking about it today. And there were, much like there is today, vice units assigned to this issue. Much like today, those vice units were led by and directed by white women who operated undercover, who operated in plain clothes, and who used language and who used narratives to create stories about their untenable pregnancies, and tried to then figure out and infiltrate and disrupt networks of midwives who are mostly Central, Southern, Eastern European at that point. And then they would typically charge criminally both the woman that was receiving the abortion as well as the doctor, in order to be able to pressure, much like they do today. If you look at how sex work is prosecuted, and if you look at how a lot of drug use and possession is prosecuted, it's very similar sort of set of tools. Police are, if nothing else, pretty predictable in targeting vulnerable people, cornering them, then not giving them very many choices, but to cooperate with them. And the reason that women were often charged alongside the provider or the doctor or the midwife was to be able to sort of pinch them into cooperation. There were contempt charges. So there's a woman in the 1950s who didn't want to testify, who indeed would be self-incriminating if she testified, and she was charged for contempt. If we want to ask ourselves today, how is this likely going to be investigated? How is it going to be policed? How is it going to be surveilled? I don't think we have to guess too much. We can look at how other types of criminal conduct are currently being surveilled and policed and investigated, especially ones that, I mean, and everything these days, because every communication we have is mediated by our phones. Everything is going to be also surveilled and tracked and investigated through those devices. I'll pause there and make sure I'm not over answering.
You're fine. So I think that is kind of a good segue. You know, as we saw just a few months ago, there was a case out of Nebraska where a woman and her mother were both charged with improper disposition of fetal remains because she had done a self-managed abortion, and they were able to get essentially the evidence that they needed to bring the charges by getting a warrant and getting access to their Facebook messages. And they were tipped off by a friend that knew her. And so I think a lot of people get, too caught up in the weeds sometimes around particularly, all this data, but sometimes it's just the messages that you have on your phone. So I guess if you could speak to that, what role does technology and data play in the criminalization of abortion post-Dobbs?
Sure. That was a really stunning sort of set of facts, I think, for people that hadn't previously thought about the significance of our communications being mediated by technology in the way that they are. I believe that those messages between mother and daughter even happened while they were in the same house in the middle of the night. And so that particular fact made me think a lot about, well, what other surveillance what surveillance is mother-daughter living under inside that house that they're going back and forth on Facebook Messenger while the daughter is managing the miscarriage in the shower, and what would otherwise probably be whispers inside of a house in the middle of the night are captured by a third party who, good, bad, or otherwise, they don't have any control over. And they don't have any control over what that company does if that company chooses to collect in a way that can be saved, store, and be willing to disclose that information to law enforcement. So when law enforcement comes knocking, and what's interesting about that warrant is that the warrant never really clearly says the blanks that these messages are supposed to fill for the purposes of the investigation. And that the blanks that it did fill by revealing the messages that talked about receiving the medication abortion pills, and thus led to additional charges being brought against the mother, really demonstrates the power of how these bits and pieces of ourselves, these trails of ourselves that we extend out into the world and that get captured in these sort of corporate databases, how significant it is, and how that practice, how we think about, just the same way that we're going to think about who we share that information with, because the friend ultimately was, or someone, a third party was ultimately who tipped it off. We're not only going to think going forward about who we share with, but how we share. And I think that's going to ultimately be one of the biggest impacts of the technology that we've surrounded ourselves with. But I think that for many reasons, it's something that we all have to start paying attention to, not just in the context of protecting ourselves and our autonomy and reproductive health, but for many different reasons, to protect who we love and protect who we, how we want to die and how we want to be treated by healthcare professionals. There's going to be many different ways, that we are going to have to second guess and rethink our relationship to our devices and how we seek and share information through them with them.
So our paper kind of tackles some of the ways that states can protect the right to an abortion for their own citizens, but others that may come to seek refuge, even if they've charged in other states or if they're assisting in someone else getting an abortion in another state. So we've seen some bills passed in Connecticut, New York, California, and others. But what are kind of the more concrete ways that states can protect their citizens' ability to access abortion?
It's a good time for states to consider all the different ways that they share data throughout the country. And not just the states, also entities like hospitals. And the way that our country has been set up historically has allowed for, especially post 9/11, allowed for a great deal of interstate multi-jurisdictional data sharing. And many systems, whether they're federal sort of state-based systems or whether they're commercial systems like the license plate database company, that you buy the software and you get access to any other state that's also using the software. So there's data sharing that is just happening on multiple levels. And that, like in the context of that commercial software system database, that's being very seamlessly shared across jurisdictions. The federal and state and local police departments have all collaborated on a lot of data sharing mechanisms throughout the country. And then in addition to that, you also have a newer development around medical records also being something that the national system has just said, you know what is the best way for us to collect information about medical records? It's for each patient to have a unique identifier so that their medical record history can follow them no matter what state they're getting treated at or no matter where they, which hospital they go to. And again, the interoperability and the advantage of interoperability has grown naturally in this place where interstate was assumed to be a good thing, where the data sharing was assumed to be an advantage and not something that would introduce a problem. And so as we, look forward to creating and articulating really strong protections for people to be able to manage their body in relationship to the universe as they see fit, whether it's their reproductive health or anything else, it's an opportunity for states to reconsider how they go about sharing information and what exact mechanisms they can use to actually protect people currently. And a great deal of what we wrote about was that it's not as simple. And we know this because we can sort of look to how advocates for immigration movements have created sanctuary cities. But sort of the first stab at creating sanctuary cities, it had to be tweaked. There had to be a re-examination of how information was being shared. They found that very often, even though a city had articulated that we don't want data shared between, our local law enforcement and the immigration services, that it was being shared anyway. That peer-to-peer, police officer to police officer, there was more incentive to respond than the city officials who wrote the law that said, please don't share information, had anticipated. And so it was happening anyway. And so as we think about writing these protections, drafting these protections, we also have to think just very practically, how will they be implemented on the individual level? How will a police officer who is alerted to the existence of an extradition warrant for someone related to an abortion investigation, how will they be incentivized to act? And what kind of mechanisms can the state introduce to make sure that those set of incentives are very strongly ensuring that those officers are not going to be sort of reverting to what is expected of them, which is interstate cooperation? Because after all, that is the pavement that we've laid for the past 20 plus years in this country, is the assumption of interstate cooperation, interstate data sharing, and sort of, peer-to-peer law enforcement cooperation. And I think rolling that back somewhat, reconsidering, it's going to be a huge amount of not just sort of logistical work and rewriting and redrafting and rethinking, but it's a huge deconstruction of a lot of assumptions that we've been operating under for a very long time.
Thanks, Cynthia. I think it really kind of comes into play, post Dobbs as criminal bans come into effect. I think in a lot of ways, people think that criminalization of abortion is new. It is absolutely not. People have been charged for seeking abortion access for decades. And Yveka, you're one of the few attorneys that works at this intersection of criminal defense and abortion access. So can you tell us what's happened in the months since Dobbs has come down and how it's affected your work?
So hi y'all, my name is Yveka Pierre. I use she, her pronouns. So my work is, like Alejandra said, at the intersection of repro and crim. So what I do is I defend folks that are arrested for a pregnancy loss or helping someone through a pregnancy loss. So I know we're here really talking through the lens of abortion, but in reality, there's no morality test for prosecutors and who they're going to arrest, right? So sometimes I'm working on cases where folks are being prosecuted and what we're saying is this person experienced a stillbirth and you're prosecuting them for a murder because you're using junk science to try to determine whether a baby was born alive or not, right? And we're not automatically jumping to folks who have stillbirths, folks who experience miscarriages are going to be prosecuted. But that same through line of stigma that leads us to where we're at with Dobbs is the same through line of stigma that's causing folks to experience criminalization penalties, right? For what happens with their pregnancies. I think that's the unexpected part for some of the folks that I ultimately end up working with. I think with my work, it's been a lot of knocking on doors and banging down doors of other criminal defense attorneys saying, hey, you might want to be interested in this, back when Roe was still the law of the land. And then when Dobbs happened, for a lot of people that don't work in repro, don't really kind of traverse in these spaces, there was a lot of shock that the decision in Dobbs came down the way that it did. A lot of folks were like, holy crap, what are we going to do now? And a lot of people in repro have been kind of steeling themselves for that ultimate reality because we've been seeing the death of 1,000 cuts. So I think what it's done that's changed for my work is more folks wanting to be prepared to assist their clients. I think that there's more of this bright reality, unfortunately, for some people that are like, oh, we need to pay attention for this kind of issue now. We need to know how to defend these people if a case like this walks through the door. And I think really kind of stemming out for people how it's likely not going to be, my client went to an abortion clinic and got an abortion, and it turns out she was at 13 weeks instead of the 12 that was legal, and now I need to represent the doctor. That's likely not what we're going to see. We're likely going to be seeing, as we have been seeing over the last few decades, folks being prosecuted for self-managing their care, for seeking care outside of the clinical system. Because if someone is getting care through the clinical system, right, then it's not an illegal abortion. It's an abortion as allowed within the narrow guidelines of wherever they happen to be. The folks that are at risk of criminalization are the folks that are seeking outside of system care. So people that are sourcing pills to try to self-manage their abortion with pills, folks that are using traditional methods to try to self-manage their abortion at home, mutual aid folks that are providing access to those methods to others. Those are the people that are at risk for criminalization. And that risk of criminalization gets tighter and tighter depending on how your identity interacts with oppressive systems, right? If you are on parole and probation and cannot leave your state and are pregnant and are under constant surveillance, have diminished Fourth Amendment rights, someone can come into your house whenever they want to because you signed that document, because you're on, pre-trial release or post-trial probation. You're more at risk for being arrested than somebody that is like folks that are sitting in this room with more privilege, right? That are outside, that are further and further away from how these systems interact with criminalization. So a lot of my work now since Dobbs has been having these conversations with people and preparing others for it not to just be, 4 or 5 of us working on this issue. Everybody's welcome, please take a case.
So kind of moving to my next question. We've kind of seen over the past few months, and particularly in the political space, these kind of shock ads of, a white woman and her like 30s or 40s, with her teenage daughter driving and then getting pulled over by state troopers or state police and then getting arrested. And it's kind of, intend to kind of create a shock response. But I think that's kind of, we see that as a popular conception of maybe what criminalization looks like. But what are these kind of preconceptions different from reality?
So is anybody here on social media? I don't want to know your ad, but like, is anybody here on Twitter? Okay, it's a dying art form at this point. But right after the Dobbs decision came down, I started seeing a lot of these tweets from really well-meaning feminists that were like, if you want to come to my state and get a manicure, I will help you get a manicure and you could stay at my house until your nails dry. And it was like supposed to be kind of like, offset in some sort of way. And, this, I can drive my van around and like get you the help that you need from like well-meaning folks. And frankly, there are already systems that exist to help people access abortions. They're called abortion funds, and they've existed for a really, really long time. So I think that what folks are trying to do is show sympathetic characters to get people to react, right? And I think there's part of us that needs to navigate through why the sympathetic character is a white woman in her 30s with her blonde daughter or her brunette daughter in these ads. And it's not folks that are more likely to be criminalized. I think that there's some self-examining that we need to do about like, why don't we feel sympathy for other people that look differently than folks with these types of privileges? But it's emblematic of how we ended up in this space at all, right? Because when the rights were starting to get just sliced off, like you're getting a euro somewhere, just like slice. And so all we're left now is with this metal pole with tendons on it, right? When the rights were getting sliced off, and the folks that it was affecting, starting with the Hyde Amendment, dude, like poor people not being able to access abortion in states due to the Hyde Amendment, that happened. But 1980 was when Harris v. McCrae came down. So you're talking about 6-7 years after Roe was in place. So almost for as long as we had Roe, we had the Hyde Amendment keeping hundreds of thousands of people on a yearly basis from being able to access the abortion that they wanted and needed. That was okay until the folks that like were sympathetic, that the stigma didn't really touch, started becoming affected. So this was always an issue, and these ads are intended to kind of show people that it's an issue. But the way that it's really showing up is the way that it's shown up for years and for decades. A colleague of mine, Laura Huss, did a 2-year research project, and the goal was to find these cases where folks were arrested for self-managing their abortion or to help someone do so. Her time span was like 2000 to 2020. And for the longest time, I think we were saying something like, we know of 21 cases that have existed since 1973. But her research project going from 2000 to 2020 found about 61 cases across 26 states of folks being arrested for self-managing their abortion. It's an ongoing project. So there's still more cases that they're uncovering. But I think what that shows us is we're seeing cases where folks were being arrested in that 20-year time span in quote unquote blue progressive places, right? We're seeing folks getting arrested for self-managing their care in places where you would expect. But what it's really showing us is that it has been happening undercover. And it has looked very different depending on where you're at. A prosecutor could charge somebody with a homicide and say that actually you gave birth to a live-born baby despite it being a stillbirth. Or it could be like in the case that Alejandra and Cynthia were talking about, where it was someone clearly did not give birth to a live-born child, and they're now charging you for what you did with the fetal remains, despite the fact that there are no clear laws on what you should do with the fetal remains, right? So that's the unsexy part of the law, that it's not going to be the thing that galvanizes necessarily every single person into immediate sympathy, but breaking down the stigma. So we're looking at everyone as someone being worthy of protection and worthy of access and worthy of rights. That's where the work is really happening. At least I hope that's where the work is really happening.
Yeah, and so I think to kind of
A lot of words, sorry.
I think going back to your point about Twitter, immediately post Dobbs, I think one of the things that we saw was people immediately saying, delete Flow, delete your menstrual tracking apps, and kind of, again, I think well-meaning people that were trying to hand out good advice, but I think as we've seen, it's not necessarily the things that you think are the most immediate. It's oftentimes the thing that seems the most banal that actually are used in criminal prosecutions. I think the phrase that you've used multiple times I like is hell is other people. Yeah. And going back to the Nebraska example, it was one of the person's friends that initially tipped off law enforcement that kickstarted the entire investigation. So it didn't matter necessarily. Your OPSEC is only as good as the people that you talk to. And so I guess, kind of piggybacking off the second question, I think there's a conception of the way that technology plays a role in criminalization of abortion, but how does it actually play out in ways that you've seen in the prosecution of people seeking access to abortion care or self-managed abortions?
I think it plays out in the way that it plays out in a lot of criminal cases that have nothing to do with abortion. I don't know kind of the folks sitting in the room, how many people have ever sat in a courtroom and watched a criminal trial. They're not recording. I'm just very curious if there's like a hand or two. Okay, like a few people have, or sat on a jury and been on a jury for a criminal case. What we've seen in the last couple decades, frankly, is that digital data, things like your phone, your laptop, your desktop, the information that's contained therein ends up being part of a lot of criminal cases. So like when you get arrested, and if anyone's ever been to a protest and they say don't bring your phone to a protest, this is one of the reasons why, right? When you get arrested, your item becomes part of they're taking that evidence subject to arrest. And now they can go to a judge and get a warrant and then go and extract everything that's on your cell phone. And they can do it through Cellbrite, through Gray Key, through whatever the police force can afford. And they take all of that data and they start parsing it out for keywords. They can start parsing it out for misoprostol, mifepristone. They'll parse it out for, did you go search for an abortion clinic in your Safari, right? They can start parsing it out for anything that would be helpful in prosecuting you in a case. And it's not unique to abortion. They do it if you're arrested for pretty much anything else, right? If you're getting arrested for a drug case, they want to find out who your dealer is. They're going to go and see if you have any text messages. And people are not as slick as they think they are. Like if you are doing the Venmo payment and it's like a tree or the leaf blowing in the air, everybody knows what that is. If you're going to buy the mifepristone and you're sending the pill emoji, they're going to figure out what that is, right? So I think that's kind of the thing that people are uncomfortable with, how we just use our phones to do things all the time. And even when we think we're being careful, we're not that careful because no one's moving with the expectation that my phone will be out of my hand and someone will be able to look through literally everything I've ever done on it. Because for the most part, like a lot of people are not getting close to criminalization. That's not what they're doing. They don't think about like, I need to go and put up my VPN before I go on certain websites and then make sure that they can't track my IP address. A lot of us we're not thinking that way. So that's the way that it's actually showing up in cases. So I really just, tiny little soapbox, I'm gonna step on it to talk about period apps. It is a terrifying thing that the app that you're using to let you know when you can't wear white pants this month would be used against you in a criminal case, right? The way that is likely to be used is your phone is taken away, your laptop, your tablet, whatever, and then someone is able to get access to that app and say, look, judge, she knew she was pregnant because she tracked her last period to be that day. And that's how she knew she was at that gestational age. And we can move forward with the prosecution for that reason. It's unlikely going to be, it's not going to be, the police are going to subpoena Flo and then get all of the data of everyone that menstruates and then trying to backtrack whether those people were pregnant. Like that's kind of the way that it's been shown in the media. It's going to be this big net that's going to draw everybody in. It's likely going to be, again, the people that are closer to criminalization ultimately are arrested and then they build the case backwards. Because unfortunately, that's how our criminal legal system works. Cops are not waiting until they're like, we have a case beyond reasonable doubt before they go and arrest someone and disrupt their lives, right? They say close enough and then they arrest you and then they build their case before it gets to a court of law and they're still investigating it up until you're in front of a judge and they keep giving discovery to people that look like me. So tiny soapbox, I'll step off of it now. But I just want that to be clear. Like the way that data is used in criminal cases is used in all types of cases. It's not special to abortion. So one of the things that we need to start thinking about is what are the Fourth Amendment protections that we're giving up by allowing it to happen to people that we don't like? So if it's okay for them to do whatever they want to do with a device in a sex crimes case, because you are like, that person did something that I really disagree with, and it's really awful and it's immoral, and I want to see them arrested. If you're allowing the rights to be sliced away for the people that you don't like, the rights don't exist when it's the thing you care about. Yeah. So I accidentally got on a second soapbox, but I think that one.
I think that's a good point. So I want to shift over to Kate, who's works at the Digital Defense Fund. And the way I kind of describe it, and please correct me if I think this is perfect, but you're essentially the tech support for the abortion rights movement. Kind of working at this unique intersection of cybersecurity and abortion access. And so, particularly in this space, I think this is an area that a lot of legacy rights orgs, whether it be in the abortion rights space or the LGBTQ rights space, I think this is an area that hasn't been as well invested in. I think you're really at the forefront of this. So kind of what are the immediate challenges that you've seen for abortion funds and abortion providers post Dobbs, particularly with regards to their security and technology.
Absolutely. And as like a little bit of context for that question, the Digital Defense Fund provides a lot of what we're starting to call technical assistance to the movement. So we will go in and do digital security evaluations. All of it's free. We do a lot of trainings. We connect people with different vendors and other solutions providers. We provide grants for any of the improvements that we think need to be made. And so a lot of the work that we've been doing to date has been on preparedness for just the general environment often that nonprofits inhabit, which is that they are targeted for even financial crimes. I think that is actually one of the more common things that tends to fall by the wayside, because we also then deal with ideologically motivated crimes. So there's often groups that are looking to eradicate abortion, also then do things like try to take down websites and dox people and try to send them threats. So now we have this new dimension of threats that, while it occupied certain spaces, because as we described, abortion has been criminalized prior, and that there are certain states that have taken a more active role than others in trying to include the organizations that provide that support as part of that criminalization. But the big challenge, I think, is that we are stepping into a lot of unknowns. And so organizations that to date dealt with often the sort of presumption that it is legal for abortion is the law of the land. I am able to help people get their abortions in certain circumstances that are defined by my state law or otherwise. Now we're stepping into these spaces where there are possible escalations that we haven't yet seen, but they cause chilling effects. I think one of the big ones was SB 8 before Dobbs' decision actually came down. Texas SB 8, which was sort of this like civil suit bill, came down, and it actually didn't require anybody to file any of those private suits. That effect was enough to get providers in the state to shut down. People act often out of fear of what is possible rather than what we've seen has happened. So I think one big challenge is staying grounded in sort of what we know to date. And for that, I've been extremely, it's invaluable, the amount of work that F1 How has done on this. I think the reports on that we attach to pretty much every training that we do, just because seeing who has been the sort of initiator of a criminal case or an allegation of an individual crime, that it's often been people who are either in the person's life or otherwise responsible for their care in some way, or a representative of the state. That helps us to help organizations to take all of the things that could possibly happen to you and sort of threat model them more effectively. So are there certain questions that I can ask when I'm doing intake for somebody who needs help paying for an abortion that might help flag to me that that person may be more at risk from people in their household? I'm glad we were actually talking about in-household surveillance, because among the many kinds of person who are more likely to encounter an issue later with being reported for their abortion, it's often people who have people in their lives who disagree with their decision. They might be a minor in a household with parents that disagree. They might have a domestic violence situation that they're trying to navigate effectively. And I think all of that sort of helps us take the lessons that we need to learn both from other movements. So we're able to take a lot of that really wonderful wisdom from people who do a lot of anti-surveillance work around both, what they call like technology abuse. So like the ways in which people install surveillance apps on people's household devices, people who work in harm reduction communities who understand what the kind of in-household surveillance and also surveillance by things like the family policing system can look like for people who use drugs or who have prior. And all of those kind of help us factor in sort of what the expectations can be for you as an organization that provides direct services to those folks. So we are still learning and growing. I am deeply grateful for all of the different other movements that have kind of shared in and worked with us to help develop that threat model further, to ensure that people actually have technology solutions that help them meet those, like we're all getting advice from lawyers in like 100 directions right now. We have all kinds of great new research coming out all the time telling us like what are some dimensions we should be thinking about. Often organizations are getting even different advice from their own counsel. And our job at Digital Defense Fund has become to help people make technology decisions that are able to reinforce some of that advice by default. So I shouldn't have to go through each individual case and make choices about whether I am increasing the risk profile for this individual person. I am just knowing that we've tried to build our support systems as best we can to limit the amount of data that's retained, that we try to move people who may be in sensitive situations to more encrypted channels by default, and that we often help that person to understand the environment that they're interacting in, because your interaction with me as the abortion fund or the practical support group helping you travel is not going to be the last time you engage with anybody who's going to need to generate or collect information about your abortion. So it's in this way, we're hoping also to not just solve individual technology assistance problems or just, the IT questions, but to change the environment that people are interacting in, because I do fully believe that you have a right to take up space, and that includes online. You have the right to access high quality, secure, accessible technology to help you obtain your abortion. I am fully a firm believer that we do not get chased out of the public square or off of all of these tools that should facilitate, our autonomous, secure decisions. So, that's part of the challenges. I'm sure there'll be more. So.
Yeah, so kind of moving away from specific organizations, I think kind of the theme of the panel so far is just kind of well-meaning advice that's been out there. And I think oftentimes people always think that, there's just this one neat trick that you need to do to protect yourselves. And in many ways, it's actually much more complicated than that. So I think, what are kind of the ways that you think people can minimize the amount of data that they're giving out and the ways that they kind of protect that?
Yeah, this is a really great question, because I think often when we go and speak to either people who are in the community or working with organizations, they're often a little surprised at how simple some things are, because so much is out of our control. And often, in the course of just our daily lives, like, information is generated without our consent. We don't really have a lot of control over where it goes, but we do actually have control over very few things. One of them is that we often tell people to know your rights. Don't give your phone to anybody. This includes if you work in an organization, like, be completely aware of what your rights are when engaging with these systems. They are larger than you. Ask for help when you need it. We often are challenging people to question the nonprofit industrial complex, push back on your funders on how much you need to collect and why. Can you get rid of things after you've done reporting on them? Be present and articulate your needs proactively in terms of saying, I am advocating for the people I'm serving. And that is actually part of what I get to offer as this, human rights organization. And so I just think helping people sort of step into the driver's seat and know that they have the right to say no, they have the right to revoke their consent, both as the organization and also as people who are engaging with those services, is really, really important. I think also just being aware of, like, what actually is collected helps you make decisions differently. Like, I actually have very little control over, we're in ecosystems where if I need to search for something, I have a very limited number of places I should go. I shouldn't always have to expect that I'm going to have to operate as if I am a spy to be able to look for, like, where a nearest clinic is. And so I think revoking that assumption that people should just, like, use Tor, use Signal, like, just download all these tools and make everything super complicated, but just knowing that your browser saves that information, knowing that your internet service provider saves that information, you might start to pick and choose and behave differently on, like, where you go for certain information. So if we can't minimize or get rid of everything, just being aware of the footprint that's generated can help us act differently. And I think, honestly, the last big one, the one thing where we do try our best to, like, help people to understand the value of it, is that there are tools like Signal that we ask people to download and practice using. We try to help folks understand that there is just a tremendous amount of difference between, and there's, like, a chart actually that the FBI itself put out of, like, all the different metadata that you could get via a warrant from all these different chat platforms, and just seeing the size from, like, like WhatsApp and Facebook Messenger and the Signal, it's like, bleh, it's just, like, tiny, is a very useful and effective tool. We also try to frame it in that same way of, like, how, if you don't have this information retained, people often then feel freer to speak their needs. They can communicate more emotionally. Like, I think it was so important it was very unfortunate that those chat transcripts from that mother and daughter in Nebraska came to light, but I think within them was sort of like that emotional connection that we want to be available to people. I want them to be able to use secure technology to speak freely and to connect with each other emotionally and to have the space that they need, especially if they cannot speak it within their household, to have that sort of, like, comfort and safety. So I think, Signal is one of many tools that we can use that has that kind of encrypted chat that keeps the information even from the provider itself. But I think just in general, having that same entitlement to privacy and just reassuring people that while you live in this world where we're developing new surveillance technologies all the time, like, please don't lose that center if you're inside yourself that says that, like, I truly do believe that I have the right to those things. So that sort of entitlement comes first, and then we help people try to find technologies that match those values.
Yeah, so I think we have about 10 minutes left. I want to ask one more question, and we can go to the audience for any particular audience questions.
Yeah.
So, one of the things I've particularly seen that there's kind of been this corollary of the tactics in the anti-abortion movement have now been kind of co-opted in terms of gender affirming care, particularly these tactics of networked harassment, doxing, threats against providers. This is something that has long been a feature, and for abortion providers, but is becoming more common in the gender affirming care context. So, kind of, can you explain the role that doxing and cyber stalking and digital threats play in limiting access to care?
Absolutely. I like that we sort of dug into sort of that right to take up space and the importance that has, especially when some people live in places where they cannot access care, they're not sure what their rights are. Often then we rely on people to sort of be in the public square and say, I'm over here, please come find me, I can help. When those people are targeted, and the chilling effect that occurs is actually sort of larger than the sum of its parts. Unfortunately, you have what can in reality be like a dedicated person making life hell for one other particular person. But what it does is it causes everybody to kind of contract and shrink up and worry that they should not advertise their services or figure out a way to be better available to people whose options are more limited. I mean, we actually talked a little bit about how this was sort of a big sea change in the abortion access movement in general, was that we had to all just kind of like take a deep breath and understand that all the antis kind of know where the clinics are. So if we withhold lists of those, the only people who can't find them are patients. And I think for every movement now, we're seeing this sort of same, unfortunately, the same exact bad actors are coming and, using the same tactics, whether it's a combination of online harassment, elevation now to platforms that basically the same kind of abuse that's been decades long has now the amplification power of cloud computing to make it really cheap and accessible to harass people across like many hundreds of thousands of impressions versus it would have been just you standing there with your ugly sign in front of a car, pulling through the parking lot. So I think part of what we have to sort of understand is that it is the responsibility, in my opinion, is as much on the platforms to sort of understand that if you wanted to monetize all of this information, this like repeat sort of access to impressions, because like the more people watch hateful content, the more that they're refreshing the page, the more ad impressions you're going to get, then you have some kind of duty of stewardship back to the reason that you get to make all of that cash. So I think one of the things that's really important is to not allow as a movement, I think we've been pushing really hard to ensure that a lot of that same exact behavior is called out, that we're not putting people alone on an island anymore. I really deeply, deeply believe that the kind of services that the Digital Defense Fund offers need to be available within every single movement so that there are individual like threat models and different bad actors, and that we can work together and share them, because like it's really, really hard watching trans activists and people who provide trans healthcare go through the exact same cycle of violence that the anti-abortion or folks have. Actually, the exact same people have put against abortion providers and activists for many, many decades now. So I think now with that like value of hindsight, we can be active in ensuring that doesn't happen anymore, because like the more that we actually do this together, the less that we actually have to do, because the case just becomes obvious. These are parts of people's lives that like trans people have abortions, and people go through many parts of their lives where they might use drugs or be a sex worker or engage with other issues that bodily autonomy, like being a person, like when you are actually pregnant and giving birth is another time that like you're incredibly policed. And I think like all of these people, if we bring ourselves together and make singular demands of these platforms and also of policymakers, then we have those opportunities to kind of make an impact where perhaps any of us alone were too strapped actually helping people get the services they need to live their lives. So yeah.
So,
Yes, to all of that.
so I want to give some time to audience members to ask some questions. So if you have any particular questions, I think there's a mic that was going around. Feel free to go ahead.
Thank you. Very enlightening panel and on very important topics. I'm sorry, I have to ask a legal question. How do you think about the individuals and groups? This is open for everybody. The individuals and groups who you give advice to on how to protect their personal data when either they're obtaining an abortion or performing one.
Mhm.
How do you think about giving them advice without being liable for aiding and abetting something that is criminalized in some states?
That is actually a really, really good question because we encounter a lot of that. I often try to take from my colleagues the very underlying assumption, and that even can be the first part of a conversation we'll have, which is I'm like, the law is not a box I can draw on the floor. If I stand inside the box, I'm going to be fine. You have to learn to make these sort of like judgment calls as you go. Some of the things that you're going to do is actually like, who's going to help you answer questions when you come to an ambiguity? Like that's part of the decision making as well. I think also like, I try to reiterate to people, like there is no law saying you are required to create a digital footprint of your abortion. And there is no law saying that barring litigation holds that you cannot delete one. So like this, dimension that's added to the experience is a modern construction, and that like we have the right to retain as much as we can. I know that I also tell people if you're a provider, there are specific laws that are required often by like health departments and things. So like meet those minimums, but you do not have to retain any more than that. And I think honestly, we actually try to also ensure people have access to great counsel, because if it does come to the point where you need to say, make me, I encourage people, don't comply in advance, like make them come make you. We'll have the kinds of legal support that you need to be able to back that up. And I'll pass this also to folks who make that kind of advice.
I would also encourage folks to remember that the First Amendment is still a thing.
Yes.
It's not a thing that's gone. So being able to provide legal information to people or provide where folks can access information is fairly within the understanding of the First Amendment. It's not telling someone you must delete your data, you need to hide this information, but saying that this is how information is processed.
Yeah.
This is where this information exists. That's good old freedom of speech, folks. I would challenge. And I think that some conversations, you might be having them with someone, you're like, you need to be able to talk to someone within an attorney-client privilege type of conversation. And that's why we have a legal helpline at If When How, that if someone is seeking information about what's legal in my state, what can I do, can't I do, where can I go to access things? If you are like, I don't think I can answer this question because I'm not your attorney, send them over to someone that can be their attorney.
Yes.
And I think that's we still also have a right to counsels for
Absolutely.
now. Everything still feels ambiguous. I haven't lost a constitutional right before, so I'm like, I hope I don't lose another one.
I know, right?
Can I add one thing to that?
Please.
Personally or organizationally, I encourage everyone to have their own operational security plans, and that includes data retention policies. And so perhaps you individually, or perhaps you and your organization, you wash your email inbox every 3 months, or you have disappearing messages with certain people as a policy. And so I really encourage people to rethink, and I've rethought with my family members and cousins and a lot of people in my life over the last 6 months. This is how we communicate. This is when we communicate. If this is happening for you, this is how you reach out to me. And it's going to be, as going back to sort of like the conversation about the period app panic. And as Yveka said, like that's not providing the most useful information to the prosecutors in the first place. The other thing that really fails to address is the question of like who gets criminalized. And there's a vast amount of information that people on probation and parole and who are subject to immigration check-ins are involuntarily being forced to share through the electronic monitoring services, whether those are ankle monitors or whether those are the apps that they have. There's a lot of information involuntarily being taken from people that will inevitably also pinch them in the way that they're forced to create data that they don't that they don't have this like ability to say, I have this data retention policy, probation officer, sorry, I'm not going to have my location data on all the time, right? So we have to understand that within the conversation about what we can all do and can't do, that it's all worth rethinking, but it is very much, as we think through these issues as policy issues, worth remembering that there's a huge amount of forensic and data collection and surveillance data collection that are happening for people involuntarily, and that they have nothing, they have no agency sometimes in those contexts. And so as important as it is to reiterate and learn about all of the ways that we can fortify our communications, the things in our heads, what we keyword search, what we text to friends, it's also really important to remember the piece that while we are doing that, there's also a great deal of construction that we're doing around data collection that doesn't let other people do that.
Yeah, so I think we're basically out of time, but I want to get one question, but we got to do kind of rapid fire answers.
Yeah,
So
okay.
go ahead.
Sure, yeah. Thank you so much for this fantastic panel. My question is a little bit more for Yveka. You mentioned that there's kind of a Fourth Amendment implication here, and I'm wondering like what you think about the application of that doctrine into the reproductive health setting. I think it's really interesting that there's like a concentration of that, you know, the case line focus on like GPS data, cellular data, heat tracking data, but there isn't quite as much of focus, historically at least, right, on repro data. So wondering kind of ways in which you think that that doctrine when applied in this context might be kind of stretched a little bit thin or in need of maybe a little bit more reform as well.
So I can talk about it specifically and how it shows up in criminal cases, and I'll do it very quickly. So the ways that folks are able to access your data, the amount of information that they're able to get on a warrant, but when you do a search warrant in front of a judge and they're able to pull out literally every single piece of something in your phone, despite its relevance or irrelevance to what's happening in the case. We don't tend to argue that in cases. We don't have a lot of case law that folks can cite to when it comes to time to argue that, because we haven't really pushed back on it. And quite frankly, a lot of Fourth Amendment jurisprudence comes out of sex abuse and child pornography cases and things of that regard. And that's why we see judges bending over backwards to thin out the Fourth Amendment jurisprudence when it comes to the digital divide, right? So encouraging attorneys to actually fight back and quash subpoenas when they come up in their cases, encouraging attorneys to ask for, like, if you're a Dobbs or a Fry jurisdiction, who is coming into court to talk about the data that was collected, filing motions saying that this is in violation of my client's Fourth Amendment rights. It's not narrowly tailored to the information that's relevant. I think all of that work can be done, not just in the repro context, but in the criminal defense context in general, because the more that we're actually activating these muscles, the more likely it is that we will have something to activate.
Yeah. Well, I want to thank you all so much for coming and making all the way out here for this panel. If anyone wants to kind of hear more from particularly me and Cynthia and Yveka, particularly on interstate extradition, we have our law review article coming out next month in the CUNY Law Review on interstate extradition. I also want to shout out Hillary, who is also a co-author on that paper, did a wonderful job helping to co-write that paper. But I want to thank everyone for coming. This is an incredibly important time. And if you have not voted today, please go out and vote. The rights that we discussed here today are very much dependent on how you vote. So with that being said, have a wonderful day and thank you for coming.